Good afternoon. I'm David Levy, Dean of the Law School. Welcome to the annual Frey Lecture in Intellectual Property. This lecture was established by our graduate, Kip Frey, and his wife, Meredith. Kip had a great career in law and business. It continues to this day. I learned the other night that as K. Allen Frey, he even served for a time as executive director of the World Championship Wrestling Association, which was part of the Turner Organization. You can look it up on YouTube if you don't believe me. He teaches at the law school and in the public policy school, and he directs our law and entrepreneurship program. Each year, the Frey Lecture brings a very distinguished thinker, scholar, or practitioner to the law school to discuss issues related to intellectual property and innovation. We have a very strong group of research faculty members in this field: Artie Rye, Jamie Boyle, Jerry Reichman, and David Lang. And it is entirely fair and quite an understatement to say that from year to year they don't always agree on who should be invited to give the annual Frey Lecture. But this year it was easy. There was enthusiasm, there was unanimity, and the only disagreement was on who should make the first contact with Professor Paul Goldstein. And I inserted myself and settled it by saying that the faculty member who had had Professor Goldstein for property would be the appropriate person to make the outreach. And that turned out to be me. And we are very fortunate to have him here today. Professor Jamie Boyle has the honor of the introduction. As you all know, Professor Boyle is our brilliant William Neal Reynolds Professor at Duke Law School. He's a leader in the study of the public domain. He is the director of the Duke Law Center of that name. He is a founding director of Creative Commons. His books and articles are path-breaking and, of course, are freely available on the World Wide Web. Professor Boyle.
Thank you, David. I liked your intro because you said we have great thinkers or scholars or practitioners, and in Paul Goldstein we have all of the above. I will also add novelist, and as an attempted novelist myself, I would add with more than a note of envy, successful novelist. Irritating that someone could be good in all of these fields. We talk about people who are eminent using a variety of metaphors or similes. We talk of rock stars, of lions, of giants. Paul is a lionish rock star giant, or perhaps a giant lion who also plays in a boy band. I'm not sure, but in any event, he dominates the field. If you look at for example, Copyright's Highway, written in 1994, and may I point out to those of you in the audience, some of whom weren't alive in 1994, this is a period 2 years after the invention of the World Wide Web, not the internet, but the World Wide Web. The subtitle of the book, From Gutenberg to the Celestial Jukebox. He imagines a moment where one would be able to get from any device any content, any movie, any novel, any music that one wanted. Of course, he imagined it as a jukebox where one would have to actually put money in to get it rather than downloading it freely, and perhaps only in that regard he was off a little bit in his prediction. But in everything else, I think his predictions have come true. Paul is an astounding figure in our field, a person who writes treatises, who writes casebooks, who, as I've said, has contributed to the law through his work as a practitioner. And it's truly an honor to have him here. But I'm going to go off script and add just a little bit more, which is, this is the Frey Lecture. Kip, sadly, couldn't be here today, but Kip is one of our dear friends and colleagues, also the director of what I think is quite clearly the best program in law and entrepreneurship in the country. And what most of you may not know is that if Kip and Meredith had their druthers, the Frey Lecture would in fact be called the Lang Lecture and not the Frey Lecture, but David Lang, perhaps because of his stern refusal to acknowledge large rights of publicity in intellectual property has, in fact, refused to have the lecture named that way. David has announced that he's retiring. We're not. I mean, maybe he is, maybe he isn't. He says he's retiring. I just want to also take this occasion to say that this is a very special moment for us because David is someone who, like Paul, has been a visionary in the field of intellectual property. He has thought widely and thought well. In his most famous article on the public domain, he talks of the fact that people think about the public domain as something which is infinite, something which is, we don't need to worry about, something which is there. It's just like the buffalo in the Wild West. And he concludes with the line, "And where are the buffalo now?" Between David's concern for the public domain and Paul's concern that the celestial jukebox not be the celestial ripoff, we have here two of the giants of intellectual property. And so I welcome Paul Goldstein. Thank you.
Thanks very much, Jamie, for the lovely introduction. Thank you, David, as well. You didn't sit in the front row when you were in class at Stanford. I remember that. You sat right over there. And David Lang, congratulations on your retirement at not the end, but a stopping point in a phenomenal career. Thank you all for coming. I am truly honored to have been asked to give this lecture. It's a pleasure, too, to come to one of the great American law schools to talk about a subject about which I am absolutely passionate. It doesn't get any better than that. The title of my remarks is The Americanization of Global Copyright Norms. 50 years ago, no sober observer of the international copyright scene would have predicted that the United States of America would one day set the standards for global copyright protection. In the 1960s, as today, the Berne Convention for the Protection of Literary and Artistic Works dominated copyright lawmaking around the world, rejecting formalities as a condition to protection and imposing rigorous minimum standards in order to guard the economic and moral rights of authors. Not only was the United States a stranger to the Berne Treaty, we didn't join the Berne Convention until March 1989, but America's formality-filled statute, with its broad exceptions to economic rights and its complete failure to protect the moral rights of the author, seemed destined to keep this country an outsider. Of these three American eccentricities, formalities, major exceptions to economic rights, no moral rights at all, it is the 1976 Copyright Act's wide exceptions to economic rights that are institutionally the most salient today. And I propose in my remarks to show first how American exceptions to economic rights are rapidly becoming the international rule, not the international exception. And second, taking the view from 30,000 feet, I propose to show how this transformation is both contributing to and being propelled by a far more sweeping and disruptive sectoral shift in the markets for cultural production worldwide. A shift that portends a return to the conditions for creativity that last obtained before the Berne Treaty and indeed before copyright first began to emerge in the early 18th century. As a footnote to that second observation, I can tell you that in 50 years, or close to 50 years, writing about copyright law, I have successfully resisted the operatic attractions of titling an article, "The Death of Copyright." But I will tell you that if the dean's office here at Duke had not been so insistent that I provide them with a title eons before the date of the lecture itself, much less its writing, in light of this second development that I have referred to, it would have been titled "The Death of Copyright," because that is the point to which the story I will tell you leads. The story begins in the 1970s, and paradoxically, not with a contraction of copyright law's economic rights, but with the expansion of its subject matter, specifically with the move to bring computer programs into copyright rather than submit them to a sui generis, custom-designed regime designed to fit the circumstances of software production. Why would a software producer, much less society, prefer copyright to a custom-crafted sui generis law? As is so often the case, the answer turned on point of view. If you owned an entrenched computer platform on which other equipment producers wished to interoperate, think of IBM owning the mainframe platform, IBM would choose copyright protection for software because of the power that copyright's exclusive rights confer to control whether and on what terms others can profit by attaching to or competing on that platform. If, however, you were a producer of attaching or competing products, your preference would be a sui generis law that replaced copyright's exclusive and exclusionary rights with compulsory licensing on reasonable terms. Yes, you can attach on the platform, you just must pay a reasonable fee for it. The battle between those two sides, copyright sui generis, was the fiercest that I have seen in almost 50 years at the copyright ringside. And when the final bell rang, copyright was the victor, with a series of U.S. court decisions holding that computer programs are copyrightable as literary works, and with the Copyright Act itself being amended in 1980 to bring computer programs into copyright. The battle was fought on foreign fronts as well, most notably in Japan and the European Union, and with the same result, so that as enshrined today in the globally adopted WTO TRIPS agreement and the WIPO copyright treaty, I'm quoting, "Computer programs are protected as literary works within the meaning of Article 2 of the Berne Convention." America wins. Now, although the American government led the fight for copyright as the appropriate global norm for the protection of computer programs, it should be evident that the American position is not quintessentially American in the sense that apple pie is American or Boston baked beans, but rather in the sense that the position reflected the ascendancy at that time in America's political economy of computer companies like IBM committed to preserving their entrenched platforms. Just as the opposition was neither quintessentially Japanese or European, but rather a response to the plight of local computer companies that wished to interoperate on entrenched American-made platforms. Still, there is no small irony in the picture of the United States of America, this Berne outsider, instructing other nations, among them the Berne Treaty's earliest signers, on the meaning of Article 2 of the Berne Convention, just as there is no small poetry in the fact that the leadoff witness at the Senate hearings on U.S. adherence to Berne was the Vice President of Law and External Relations at IBM. In the end, America's copyright for computers proponents did not get quite the bargain that they sought. Copyright law, and this is one of the reasons I'm passionate about it, copyright law has an internal competitive logic all its own. And by the early 1990s, American courts applying the law's pivotal idea-expression distinction severely limited the extent to which copyright would protect the elements of a computer program needed to achieve interoperability. Also, under the Fair Use Doctrine, courts carved out a defense entitling competitors to copy entire computer programs for the purpose of achieving interoperability. Even Europe's rigid authors' rights doctrine gave way in the face of competitive needs. And this is a harbinger of the erosions to come. The 1991 EC Software Directive similarly created exceptions to enable software interoperability. These moderations notwithstanding, copyright has reaped the whirlwind. For the bulldozer, high protectionist positions advanced in the software debates triggered a skepticism toward copyright. Antagonism might be the more accurate word, first in the academy and then in the popular media, so that by 1998, when Congress made the momentous mistake of extending copyright term by 20 years, there was already a sitting and now permanent grand jury of copyright critics ready to indict even the less ambitious expansions of copyright. Who knows? Without the computer wars, there might not be a Duke Center for the Study of the Public Domain. Certainly, it was in these trenches that I first met Jamie Boyle, David Lang, and Jerry Reichman. The whirlwind I refer to shows no sign of abating, and it has today caught up economic rights in its vortex, and with it, with economic rights, the question of appropriate defenses, exceptions, and limitations. Historically, copyright defenses, exceptions, and limitations around the world occupy a spectrum from broad and flexible at one end to narrow and rigid on the other. If you were to draw a cartoon of this spectrum, America would be on the far left pole, a sort of Looney Tunes Yosemite Sam, if you remember Yosemite Sam, holding a blazing six-shooter, blasting holes in exclusive rights as if they were ducks in a penny arcade. At the other pole are the civil law countries of the European continent and elsewhere. Picture Madame Defarge knitting the tightest encoded knots into the fabric of authors' rights law. And in the middle, patrolling the fair dealing precincts of Britain and the Commonwealth countries, is the formidable Jeeves with his yes sir, no sir. Fair use, the doctrine that came to the rescue of software interoperability, is the central emblem of America's flexible administration of exclusive rights. As embodied in Section 107 of the 1976 Copyright Act, fair use subjects 6 illustrative categories of use: criticism, comment, news reporting, teaching, scholarship, and research, subjects these categories of uses to scrutiny in light of 4 statutorily prescribed factors: purpose of the use, nature of the copyrighted work, amount taken, and the effect of the use on the market for the copyrighted work. Although fair use is the emblem of American copyright permissiveness, the extraordinary array of exceptions and limitations embodied in sections 108 through 122 of the 1976 Act, from exceptions for interlibrary loan to copies for the blind, are no less sweeping in their compass. Okay, fair use, major exceptions, Yosemite Sam. What was the global stature of American fair use a quarter century ago? If you study the deliberations that led to U.S. adherence to the Berne Convention, you will find that fair use was the doctrine that dared not speak its name. For no other country in the world at the time accepted fair use as a defense to a copyright claim, a fact that no doubt increased the concerns inside the U.S. and out that the doctrine would violate the Berne Treaty's minimum standards. But starting in 1997, Berne Union countries have adopted statutory provisions that are identical or virtually so to American fair use. Liberia, Singapore, Israel, Korea, the Philippines, Sri Lanka. The list, I promise you, will grow. The Australians have been playing footsie with American fair use since the turn of the present century, and according to Bernd Hugenholtz, my co-author, the Dutch government, and I'm quoting, has repeatedly stated its commitment to initiate a discussion at the European political level on a European-style fair use rule. Hugenholtz's observation has particular resonance in a year in which the European Union has announced its digital single market initiative that has as one of its features a sweeping review of copyright norms in Europe. Fair use aside, what impact have American-style exceptions and limitations had abroad? The EU's 2001 Copyright in the Information Society Directive plainly nudges Europe toward the middle of the spectrum I referred to, and to some extent beyond, offering options that not only encompass the narrow civil law limitations of the continent, Madame Defarge's knitting, but also the more generally phrased uses of the common law fair dealing tradition, think Jeeves. Under the directive, Britain in 2013 introduced or expanded 9 exceptions to economic rights, including uses for purposes of teaching, parody, quotation, and private copies. Across the American border, Canada in 2012 received royal assent to its Copyright Modernization Act, expanding the scope of fair dealing along lines roughly comparable to the British project. Indeed, in its own zeal for fair dealing, Canada's Supreme Court has done American courts one better by characterizing fair dealing not merely as a privilege or as a defense, but as an invincible user's right, a goal much sought after by some American academics. Now, breaches once opened possess an inertia all their own. Is there any principle that will stop economic rights from unraveling completely? If the trajectory I have described is accurate, and I believe it is, what end is there to this unraveling of copyright's exclusive rights? Now, the Berne Treaty specifies a small handful of narrow exceptions permitted to its minimum exclusive rights. More consequential, I think, than those narrow exceptions are Berne Article 9.2's so-called three-step test, defining the limits on exceptions to the reproduction right, and also Berne's unwritten minor exceptions doctrine that effectively does the same for the public performance right. What does the three-step test permit? What does it require as a limitation on the unraveling of rights? The three-step test allows Berne member countries to permit the reproduction of protected literary and artistic works, and I'm quoting, one, in certain special cases, provided that two, such reproduction does not conflict with a normal exploitation of the work, and three, does not unreasonably prejudice the legitimate interests of the author. With modest changes, the three-step test has since become a standard, really the standard, for limitations and exceptions not only in every contemporary copyright and neighboring rights treaty, but also in EU copyrighted-related directives and in the WTO TRIPS agreement, where the test carries freight not only for copyright, but for permitted exceptions and limitations under patent, trademark, and industrial design as well. What hath copyright wrought? Now, if in the three-step formula that I just described, you heard echoes of Section 107's fair use formulation, your ears are good, your memory is good, and it is because the aims of the two doctrines are roughly comparable. The first steps, certain special cases, may have been intended to cover less ground than Section 107's 6 illustrative cases, criticism, comment, news reporting, teaching, scholarship, or research, but not dramatically so. The second step, that the use not conflict with a normal exploitation, closely parallels Section 107's fourth factor, by historical acclaim the most important factor, inviting courts to weigh the effect of the use upon the potential market for or value of the copyrighted work. Third step significantly duplicates the second, and its principal contribution, not present in American fair use, is to allow compensation to overcome an otherwise unreasonable injury to the author's legitimate interests. For those of you who are law and economics savants, what the third step contemplates is a liability rule, damages only, no injunctive relief. The true test of a limiting formula, be it fair use or three-step, is its ability to resist judicial mischief. Section 107 of the 1976 Copyright Act failed this test only a few years after its enactment, when in the Betamax home videotaping case, the U.S. Supreme Court chose entirely to ignore Section 107's threshold illustrative purposes in order to indulge its own instinct for good copyright policy and to hold that home videotaping, now this is not news reporting, teaching, scholarship, or research or comment, home videotaping of copyrighted programs off the air constituted fair use, a decision whose impact on industry practice today is absolutely impossible to overstate. I have never seen a copyright decision hang on and ramify the way the Betamax decision has. It is incredible the internet facilities that you now encounter that rest their legitimacy on a 1984 decision about a Betamax video recorder, and Betamax, of course, doesn't exist anymore. It went out of existence shortly after the decision. To take another example of how formulas like fair use and the three-step test can run amok, just consider, as I will not delay you on, the so-called Transformative Use Doctrine applied most notoriously and dangerously in the Second Circuit Court of Appeals. In the wider global landscape, and for the longer term, I am not optimistic about the containment of these notionally limiting doctrines, fair use, three-step, now that the three-step test has found a home in TRIPS, where it will be subject not only to copyright principles, but to the vagaries of international trade, and where, as I have noted, it has also become a safety valve for patents, trademarks, and designs, so that precedents drawn from those alien quarters will inevitably find their way into copyright. What explains this sudden global ardor for American-style fair use, exceptions, and limitations? These things don't just happen. They have a cause. As I noted earlier, it was the worldwide battle over software that first triggered public skepticism about copyright's very legitimacy. The political successes today in Europe of the Pirate Party, whose banner proclaims open content, among other causes, indicates how fashionable it has become to trash copyright. It is more than symbolic that the first new copyright treaty of the present century, the Marrakesh Treaty to facilitate access to published works for persons who are blind, visually impaired, or otherwise print disabled, why the Marrakesh Treaty should have as its object the minimum scope for exceptions to rights and not, as in the past, the minimum scope for rights themselves. Here is an international treaty telling member countries, and the US is one, you must provide exceptions to copyright in these circumstances, not you must provide these fundamental exclusive rights. Why is this happening? It does not require a graduate degree in economics for a national policymaker to glance at the world's most prolific producer and exporter of information and entertainment and ask, if America's production of literary and artistic works can so abundantly flourish in the face of its copyright law's many and extensive limitations, why would we do less well if we adopted similar exceptions here? Indeed, the armchair empiricist may ask whether wide exceptions are not, in fact, the very cause of America's positive balance of copyright trade. Political economy presumably also plays a role, much as it did in America's export through the 1980s and 1990s of the idea that computer programs should be protected as literary works under the Berne Convention. It is probably still too early to measure in all its dimensions the impact of internet companies in valorizing free use as a copyright norm. But at least one such company, Google, has already succeeded in transforming the cultural metaphor that information wants to be free into a hard operational reality on the ground. Copyright owners have a long history of battles with new technologies. From phonograph records at the beginning of the last century, on through film, radio, television, and cable television, every time a new technology emerged, attempting to make free use of copyrighted works, the copyright owners responded with litigation or lobbying for statutory reform. Anyone who has studied the history of these conflicts, starting with phonograph records, might understandably ask why copyright's battle should resolve any differently than the battle with these past technologies. Because in each case in the past, the lawsuit was filed, the legislation was introduced, and the former foe, within 5 years, became a new copyright ally, a copyright licensee, expanding the profits to be earned from the exploitation of a work. An infringer is really nothing more than a company waiting to be a distributor of your work. Why, looking at this history, can we not make the same prediction about the internet, the technologies of the internet? It is actually a prediction that I made 5 years ago, that the internet would succumb just as phonograph records, radio, television, cable TV did in the past. It did not happen, and it will not happen. Why and how is the internet different? The internet is different not just because of its ubiquity, cutting as it does across all copyright markets rather than one or two. The internet is different because piracy and other unlicensed uses on the internet persist and will continue to persist on a scale sufficient to drive down prices for licensed copyright uses to close to zero. When you compete with free, it is free that sets the competitive price. The technologies of the internet have created a new market equilibrium in which, for the first time, the means of delivery, the pipes, command a higher price than the content delivered. As a subscriber, you will pay less for a month of Netflix film and television content 24/7 than you will for a single matinee ticket to a movie theater. But you will also pay 10 times that amount for the broadband service that brings you that content, a price that, not coincidentally, reflects broadband's capacity to bring you free, unlicensed content as well. The Hollywood savant who proclaimed that content is king apparently hasn't met the Queen. The economic genius of copyright lies in the replicability of musical scores, CDs, and digital streams in the tens of millions, and not in the intimacy and authenticity of live performance. But if you want to see the direction in which the economics of creativity are moving today, just compare the 75% decrease in CD sales between 1999 and 2014 to the tripling of live performance revenues over that same period. The future looks more like the court of Louis XIV at Versailles than it does Tower Records. How many of you actually remember Tower Records? Not many, but more than I would have supposed. David, I would have supposed you. It is authenticity, not replicability, that will be the beating heart of tomorrow's entertainment marketplace. And in the end, copyright law has very little to say about authenticity. Now, obviously, neither the spread of copyright exceptions nor the zeitgeist that sustains them have caused what is at bottom a sectoral change in cultural markets. But it would be wrong to understate the role that widening exceptions and the new copyright zeitgeist have played in fostering the climate of unlicensed use and transforming the cultural landscape into one that looks less like the landscape immediately behind us than it does the cultural landscape of the 17th and 18th centuries, the landscape that existed before copyright law placed rights in the hands of authors and their publishers, and for the first time committed control over the conditions of authorship to the whims of the marketplace rather than those of wealthy patrons. Only one piece is missing in the global celebration of Americana that I have sketched in these remarks: the moral rights of the author, specifically the Byrne-mandated moral rights of the author to paternity and integrity respecting her work. The right of integrity or against distortion, the right of attribution. If other countries take up the American approach, granting limited rights, if any, there is small doubt that authors' moral rights of attribution and integrity will soon enough disappear into the whirlwind that I have described. But moral rights differ from economic rights, and I believe in ways that portend their survival. Indeed, quite possibly, their flourishing on today's hard digital ground. Where consumers associate economic rights with the claims of distant and easily dismissed corporate owners, They are less likely to dismiss the moral claims of flesh and blood creators, particularly those whose concerts and readings they attend. Where trespass on economic rights may have the appearance of a victimless crime, it is harder to ignore an author or artist's cry of pain when his or her work is defaced or its paternity denied. Where economic rights, if honored, require payment, Jamie, moral rights, by contrast, are free. Bound up as they are in Western notions of individuality and personhood, moral rights connect at their deepest level to the most fundamental among human aspirations. They possess a legitimacy that will, or at least should, abide the decline even of economic rights in the present age. Thank you for your patience.
Well, the professor has agreed to take a few questions, if there are some. David.
I'm just wondering if I should stand
Yeah,
here.
you
Is that
probably
okay?
should. Yeah.
Good.
Just to be sure that I have understood the last point you made against an earlier point you made, which I hope that I have. It seems to me that your last point about the recognition, a kind of, we could debate this, Jamie and I might, about whether this is an innate impulse or not, but I think there's a kind of innate impulse to recognize moral rights, which seems to me to be consistent with what you've said, also connects with the idea of authenticity as the continuing hallmark of whatever form copyright will take. And if you put those two things together, then, if I've understood you, we have copyright as it is likely to be in the, well, not the time remaining to me, but the time remaining to my daughter or to Jamie or to Jennifer or someone of that vintage, right?
That's a wonderful connection, David, that I didn't make explicit, but I entirely agree with it. When I said that, copyright has very little to do with authenticity, what you've caught me on is that I'm talking about US-style copyright that doesn't recognize moral right. In fact, the Europeans have unfortunately also adopted the American habit of calling this stuff copyright, when in fact, traditionally, the Europeans, the continental civil law countries, call what we are protecting here author's right, in which moral right is a quite natural part. So just to underline the connection you've made, yes, if moral right emerges or sustains itself outside of the U.S., there will be a bill, I am told, introduced into the U.S. Congress for moral rights. This is the first time that that's been taken seriously in a long, long time. If it emerges here, moral right then connects very effectively with authenticity in other quarters as a fundamental force in our creative lives. Yeah, great point. You want to take, or you want to offend people or me?
Jamie. I'd rather
Well,
you.
thank you. Wonderful lecture. And you've done, now my students in intellectual property, I'm going to require much more of them because you've given them a lot of the background I was otherwise going to have to teach them. So I want to conjure up the Goldstein of the 1990s, who observed optimistically, and I think correctly, that copyright's history has been a dialectic between a sort of depressive vision that the world was ending and that we needed enormous expansions of rights, and a more optimistic vision that actually, with a little loosey-goosiness in the joints and expansion and some, as you said, today's infringer is tomorrow's licensee, we could actually expand and bring technologies in. We could actually give authors, creators, the kinds of both rewards and recognition that both of us want to give them. You see a downside. You see a dark, lapse into a world of lawlessness. I see the reverse. With the exception of the Marrakesh Treaty, I see copyright having expanded dramatically in every possible dimension over the last 50 years. I don't see a single step back in statutory or treaty enactments. I see it getting bigger and bigger. I see the music business being bigger than it ever was. I see Hollywood making profits that are larger than they used to be. Where in the story you tell is that more optimistic oscillation, that dialectic between the new technology that challenges copyright and copyright's ability to respond and to take it in? Because it seems to me you're embracing only one of the stories you used to hail as a dyad.
Yeah, and it's a great point. The first, a different point of view on has copyright expanded or contracted. Over the last 50 years, there's been no explicit contraction, let's say, of the U.S. copyright law. If you don't include in contraction non-statutory initiatives such as transformative use, which has virtually, at least in the Second Circuit, written Title 17 outside of positive American law. Same development in Europe and elsewhere with carving out through widened exceptions and limitations. That's a shrinking of copyright through the back door. Somebody said, well, let's cut back the term of copyright to life plus 10, although Byrne wouldn't let us do that. That we're not going to see. But even looking at the statute, although we haven't seen contractions in the statute, what we've seen is expansions in the technology that the statute has not kept up with. We had cable television. We had 2 Supreme Court decisions saying cable television retransmission of content does not constitute copyright infringement. 2 years later, the 1976 Act is enacted with Section 111 saying, yes, let's move the statute to encompass this new technology. I think the 19th century was the century of the expansion of copyright. At best, we have copyright standing still as a matter of statute today, technology expanding, and copyright actually shrinking if you look at exceptions and limitations. But there's another point there, and this is what the cause of my disheartenment is none of this. What it is the failure of copyright owners, the copyright industries, to attend to the positive realities offered by the internet. The internet offers an unmatchable vehicle for piracy. It also offers an unmatchable vehicle for licensing. Copyright owners have been so incredibly laggard in developing technologies, and they're very modest technologies, let me tell you, for licensing. Where did the great technology for licensing come? It came from Google with Content ID, in which they can monetize some of the uses of your content on YouTube. But the copyright communities, motion picture, music, publishers, totally blew it on licensing. And what happens, and I'll just give you a story. I was talking with there's many years ago, general counsels of the motion picture companies, the studios in Los Angeles. And I said, loads of documentarians are making films that are documentaries that are taking snippets from your work. What you need to do, I can lecture to them because I'm an academic, what you need to do is develop a mechanism whereby, probably for antitrust reasons, under the aegis of the Motion Picture Association, you can license on reasonable terms to documentary makers the right to take clips from your films and include them in the documentaries. Oh, well, I said, because if you don't do that, what is going to happen is that courts are going to start characterizing that as fair use, and you're never going to have the chance to license it in the future. Take that story, write it large, and I think you have the great failure of the copyright industries in dealing with the internet. Great question. Jerry?
Well, you just answered my second question, because I think Michael Currier, I was going to ask you, I've seen Michael Currier's wonderful article on how the music industry just at every opportunity took the wrong decisions, even though knowledgeable tech-savvy people in the industry always had the right idea, and they just destroyed themselves. So you answered that question. My other question was with regard to the spread of fair use, which I find a fascinating subject. To what extent do you think the Max Planck Declaration on the three-step test has given that a fillip?
Oh, I wouldn't venture an answer. I mean, the Max Planck Institute in Munich has issued edicts before and of more or less acceptability. I think, I'll give you a one-word answer, politics, period. That's the best I can do on that one.
Deliberately intended to do that. So.
Yeah, no, I know that. I don't know.
I was going to say, we'll take one more, but it has to be from a student. And you look like a student, Artie.
Okay, well, thank you. I'm quite sure that's not the case, but in any event. So this is maybe a little bit of an unfair question, but it is a question that is very relevant to a workshop I'm going to be running in a couple of weeks on regulation of video content. So as you know, Susan Crawford and others are very concerned. You pointed out the power of the pipe owners, so Comcast, AT&T, et cetera. So why wouldn't the strategy be for the pipe owners just to own the content? And copyright is irrelevant in that context.
Well, yeah. To own the content, I think, is problematic because, what's in it for them? Certainly, if you say get rid of copyright and just own content without copyright.
So Comcast acquired NBC as
Yeah,
well.
of course.
And that was what caused the Susan Crawfords of the world to be so concerned about vertical integration and, basically the pipe owners and the content owners, the same people. Copyright is sort of irrelevant, but we're still concerned about all sorts of other values like free speech and so forth.
Yeah. Certainly one of the great virtues of copyright is as a bulwark of free speech. Comcast is not going to control what we see because we have Comcast broadband, but we don't have to watch, any universal NBC kind of content, and copyright is great for that. I don't think the economics work out that the pipe owners actually want to own this stuff. It's a completely different business. It's a hardware business. You're laying pipes. You have marginal cost of zero. Once you install the equipment, everything goes down to the bottom line. And that's the business they know, that's the business they love. Why Comcast got into that is a really long story, why they got into Universal NBC. And it's hard to argue with success. I think that given the dramatically different nature of the businesses of laying and maintaining pipes and not having the cable guy show up when he's supposed to show up is a business different from creating wonder, which is really what copyright is all about, is creating wonder.
Oh, good place to stop. Thank you very much. So,